Good afternoon and welcome. My name is Michelle Varkey and I'm Senior Legal Counsel here at MedCom. And today our presentation is going to be on employers and brokers and understanding the HIPAA requirements. I want to thank you all for attending, and just a couple of housekeeping items before we move on. This is being recorded and each of the participants will get a copy of the recording next week. In addition, if you have any questions, please don't hesitate to put them in the question box of the GoToWebinar, and we'll be sure to answer all the questions at the end. But again, today our topic is employers and brokers and understanding HIPAA requirements. So let's go ahead and get started. First off, just a little bit about MedCom Benefit Solutions. We have been in business now for over 35 years as an employee benefit administrative and consulting firm. We were actually founded in 1983. We have a head office in Jacksonville, Florida, and a regional office in Atlanta, Georgia. Our solutions entail many things, and I want to start with HIPAA since that's our conversation we're going to have today. We do offer privacy packages, security packages, as well as a total solution if you need it, as well as a privacy and security training. On our health and welfare compliance side, this has everything to do with ERISA, whether you need a VAT plan and non-discrimination testing, or anything else that has to do with health and welfare compliance under ERISA. We also offer COBRA administrative and premium billing services. Our ACA department is really robust with the consulting, compliance, reporting, and any appeal support that you may need now that the IRS is issuing penalties. And then we have a fringe benefit department that drives our consumer-driven healthcare products that include HRAs, HSAs, FSAs, and transit benefits. So once again, thank you all for attending, and let's start today to talk about HIPAA. First off, the information is intended to be used only for informational, and it does not produce any legal advice whatsoever. HIPAA, each case is case specific, and you should talk with your attorneys if you do have anything that needs legal clarification. Now, the reasons for HIPAA, when any law comes into effect, there's usually a reason behind it. And HIPAA was actually established in 1996, but the Department of Health and Human Services did not write the privacy rules until 2000 and the security rules until 2002. And they became effective for the privacy rule in 2003 and the security rule in 2005. So we have to go back to 1996 to see why HIPAA came out, why we needed these privacy and security rules. The first reason was the internet. We started to talk about the internet in the late 80s, and it came up in 1993, and it was available to us all. And there was a lot of fear. There was fear that all your personal information would be on the internet, as we know it is today, but it was who would have access to that information. And along at the same time, the Genome Project was getting underway. And the Genome Project basically said, okay, the scientists said, we're going to map the human genome. We're going to decide what each gene does in the genome, and then we're going to be able to see if maybe potentially we can cure some of the diseases. But it also led to early diagnoses of a lot of things, like we know that there's a gene for a certain type of breast cancer. We know that certain other genes can cause some devastating diseases like Huntington's chorea, which causes you to basically lose a lot of memory and things starting at a young age, and potentially even things like Parkinson's disease. And you couple that, the internet and the Genome Project, and there was a lot of fear. The fear being that all our information would be on the internet, that they would know everything about our genes, we were living in a very futuristic world, and potentially you would never get a job or you would never get insurance if employers knew that you had certain genes and that information was available on the internet. So that's what led us to HIPAA. There was a concern by the people that we needed to have our information protected to protect us. So basically there are three rules under HIPAA. The first rule is the privacy rule. It's a set of federal standards to protect health information and the privacy of that health information. The second rule is the security rule. Only makes sense if we have the internet and we have all this data going back and forth electronically. We want to make sure that we protect the integrity of the information, the availability of the information, as well as the confidentiality of the information as it goes back and forth in electronic format. And the government set up basically 3 different types of safeguards: administrative safeguards, which were basically policies and procedures, risk assessments, risk management plans; technical safeguards, everything that the systems guys would do, whether or not it's some kind of virus protection, firewall, encryption. And the third is physical: who can get access to your building, who can get access to your servers, who has access to the computers. So that was the second rule under HIPAA. And the third rule was breach notification. If the individuals in the community, and we all are concerned about our privacy, if our privacy or security is being breached, we want to know about it. And the government agreed. So they said, if somebody's security has been breached, if you release information that shouldn't be released to an unknown entity or to a person who has no right to receive it, then potentially you have a breach, and now you've got to notify the individuals involved. So all these 3 rules, which can get pretty intensive, go hand in hand. Now, the next thing is who must comply with HIPAA. Well, we all know healthcare providers. Anyone who's in the medical field has to comply with HIPAA. That's your dentists, your nurses, your psychologists, your pharmacies, everyone. But health plans have to comply too. Health plans are also considered to be covered entities, and all covered entities must comply. And the health plans that we deal with are the health insurance companies, HMOs, the employer group health plans, government programs that pay for health care, such as Medicare and Medicaid, and military and veterans health care plans. Don't ever forget that a health plan is also a covered entity under HIPAA. And when an employer sets up a health plan, whether it is self-funded or fully insured, that health plan is considered a separate legal entity, and that health plan is covered under HIPAA. And then the third were the healthcare clearinghouses. When HIPAA first came out, they also set out rules and standards for which information is transmitted electronically. You had to use the ICD-9 codes for diagnosis and the CPT codes for different types of procedures. But you also had to use various codes as they translate back and forth to the systems. And clearinghouses basically took the raw information and converted it into the acceptable electronic format. We don't have too many clearinghouses anymore because systems have gotten really smart, and that's now built into a lot of the benefit administration systems, HRIS systems, etc. So clearinghouses are a thing of the past, but in 1996, they were going strong. And then, individuals, we have rights under HIPAA too. We have the right to an accounting of disclosures. We have the right to know who sees our information. If it's for treatment, payment, or healthcare operations, we don't get to see it because those are exceptions under HIPAA, where all the information can be given to anyone for the treatment, payment, or healthcare operations. But outside of that, if my information is disclosed to any other person without my authorization, I have a right to know who it's disclosed to. I have a right to amend information so that if I get my doctor's records and my medical records and I think there's a mistake in there, I can ask to have them amended. I have the right to request restrictions. I don't want this information to be released under any circumstances. Think about a patient who has HIV. He can come up and say, under no circumstances do I want anybody, medical provider, to know that I have HIV. Now, there's some kinds of caveats with that. If you don't want your health carrier to know about that, the insurance company, then you have to pay the claims yourself out of your own funds. But you have certainly the right to request those restrictions. An individual has the right to access records, and they have the right to receive communications by alternate means or locations. So you might be sending them information via mail, and they might say, hey, I want that text to me, or I want that sent to me by email, instead of a telephone call reminding me, for an example, of an appointment. And that's fine, as long as you let them know also that It might be unsecure in the format that you're sending it in. And then individuals have a right to notice a privacy practice. This is where you tell them how their information is going to be used, and this is where you explain to the individuals what their rights are. So notices of privacy practice must go out not only to from the providers, but also from the health plans. So when you take in consideration HIPAA, think as we go through this presentation, who's going to do that? Who's going to give the individuals the right to disclosure? Who's going to give out that notice of privacy practice? And it will make more sense as we go along. So we said that health plans are covered, so let's talk about health plans. What is a group health plan? And the key phrase is health plan. It's obviously a group health plan, your dental, your major medical that you get through your employer, a health insurance carrier, an HMO, Medicare, or Medicaid. They are all health plans. So when Aetna gives you this fully insured health plan, Aetna is a health plan covered under HIPAA. So we know they include medical plans, dental plans, vision plans, flexible spending accounts, health reimbursement arrangements, and employee assistance programs. All of these are considered health plans. They reimburse providers and the various healthcare providers for their services, and they're all considered to be health plans. Not considered health plans under HIPAA is disability insurance and life insurance. Why? They do not reimburse healthcare products. They don't reimburse the providers. What they do is offer some kind of income continuance. And then the government also excluded workers' comp. But wait, you say, workers' comp does offer coverage and pays for providers sometimes if it's for a work-related injury. It does. But the government specifically excluded workers' compensation because that's handled under state law, and HIPAA is a federal law, so they specifically said workers' compensation is not covered under HIPAA. But even though we don't have the same privacy rules, when we look at those kind of claims, there is privacy concerns, and we always have to keep that in mind as well. They could be covered under the Americans with Disabilities Act. They're also covered under the laws that protect Social Security numbers, etc. So even though they're not HIPAA plans, you still have to protect the privacy and confidentiality. Well, when we talk about the difference between a self-funded health plan, because this does make a difference in HIPAA versus a fully insured plan, the first thing to remember is that a self-funded health plan, the employer assumes the risk. They are saying, I'm going to take the financial risk and I'm going to pay all the claims. However, as we know, they may limit the amount of risk they're willing to assume, and they might go to a stop loss or reinsurance carrier and say, after a specific aggregate or after a specific amount per individual, you are going to assume the risk. A self-funded health plan also typically hires a third-party administrator to do all the administration of the benefit, pay the claims, perform utilization review, do customer service, etc. So the self-funded health plan probably is not doing the administration themselves. Now, on a fully insured plan, the employer pays a fixed premium to the insurance carrier, and the insurance carrier is responsible for the claims payment, regardless of whether or not the claims are high or the claims are low. They pay all the claims. They've assumed the risk. Your premiums may go up in subsequent years, but they assume the risk of paying all those claims and the cost of all those claims. So here's a question for you. Under a fully insured health plan with no FSA or HRA, which we've already said was a self-funded health plan, how many covered entities do you have under HIPAA? And the answer is 2. Remember, we talked about that health plan that the employer sets up is a separate legal entity. It's still a health plan. And you also have the actual health plan that is being administered by the insurance company. Now, under a self-funded health plan, how many covered entities do you have? And again, the answer is you have 2. You have the self-funded health plan, that is that separate legal entity set up by the employer. And you also have the stop-loss carrier, which is considered an insurance carrier and considered a covered entity under HIPAA. So that those are the two plans. When you come down here and you say, now what about the third-party administrator? The third-party administrator is not a health plan or a covered entity. It is a business associate of the covered entity of that self-funded health plan. So you must make sure for all your self-funded health plans that you've got potentially a third-party administrator involved, and that third-party administrator, you have a business associate contract with them. Now, for a fully insured group, where you go and you get to the insurance carrier and they're paying all the claims, the government recognizes that you may not have to do everything under the privacy rule. Because remember when we talked about it, under the privacy rule, somebody has to make sure that the accounting of disclosures gets set out. Somebody has to make sure that the notice of privacy practices go out. Somebody has to make sure that the amendments go out if an individual requests an amendment. There are certain things that have to be done in those circumstances. And again, the notice of privacy practice always has to go out. So who's going to do that? And that's going to be the fully insured carrier, the Aetnas of the world, the HMOs, whoever you have, they're going to do this. So the government says, you know, in that case, you don't have to do that, and you don't have to do certain other things that we require under the privacy rule. But then they said, you know what, let's think about this a little bit more. There are really two types of fully insured plans. Option one is if the employer says the only information I want is the information on those who enrolled and those who disenrolled, and I want summary plan information, which is basically, this is how much money the plan spent during the year, this is the cost. Potentially it was broken down by diagnoses, but you don't know who the individual is. So in that case, the government said, you know what? Even though you might have some confidential information, such as social security numbers, you, Mr. Employer, already have that information. So really, you don't really have to do everything under the privacy rule. Now, you have to protect those social security numbers under different rules, but not necessarily under HIPAA privacy rule. But then for those fully insured plans that want just a little bit more information, they want to know who is sick, who is costing me money, and more information on the individuals, then HIPAA says, now you got to do more. And Mr. Plan, Mr. Carrier, Mr. HMO, before you release any information to them, you've got to make sure that they did more. So you have to make sure that the plan sponsor, the person who is sponsoring that fully insured health plan through the employer, will not use or further disclose the information other than permitted or required by the document. You must agree that the brokers abide by the same restrictions. How are you going to make sure the brokers agree and follow those restrictions? Mr. Employer's fully insured health plan, that plan sponsor, needs to get a business associate agreement in place with the broker to make sure the broker does that. You also have to make sure that you do not use anything for employment-related actions. You can't use the information you gleaned from your health plan in order to terminate or to make any employment-related decisions. So if you are a fully insured plan and you do more, then you've got to make sure that you get more things done. And they're going to ask you, for example, this is AvMed's form. Now, for a self-funded health plan, it's not considered, you are considered the health plan. You are going to have to do the notice of privacy practice. You are going to have to do everything under the privacy rule, so you need to make sure that you follow the privacy rule. But there is a hitch. The government says if you have under 50 participants in a self-funded health plan and you do not use a third-party administrator, then you do not have to follow HIPAA. So if you have an FSA and a fully insured plan, you have under 50 participants in your FSA, and you are administrating it yourself, and you're not going through a third-party administrator, then you don't have to follow HIPAA. Otherwise, you do. So the next question is, who are the covered entities with an FSA or an HRA? And the question is, who are the covered entities? It's that health plan, because the third-party administrator is not a health plan, it is the business associate. So in this case, the FSA and the HRA, you only have one plan, you only have one covered entity, and the third-party administrator is going to be the business associate, and you've got to ask the business associate what their jobs and responsibilities are. Same thing holds true for a regular health plan that goes to a third-party administrator. You will see that most likely they make it very clear they're the third-party administrator, and the health plan itself is going to have to follow all the other rules. So you will need to have privacy policies in place. So the broker as an intermediary, what does the broker need? Well, the broker, if you're a self-funded plan or if you're an option 2 on a fully insured plan, the broker, if they're receiving any information on your behalf that is more than summary information, if they have any information as it relates to any individual, then the health plan must get a business associate contract in place with the broker. What about the security rule? Well, the security rule applies to both self-funded health plans and fully insured health plans, but only if the plan creates, receives, uses, or maintains electronic protected health information. So if you're not receiving anything except summary information, you don't have to worry. But once you start creating, receiving, using, or maintaining in an electronic format any type of electronically protected health information, then you need to follow the terms of the security rule as well. So to summarize, an employee who has a fully insured group that only gets enrollment, disenrollment information, and summary information does not have to comply with HIPAA privacy services, and most likely because they do not have any PHI, they do not have to follow any of the security services either. An employer who has a fully insured group that has more than enrollment and disenrollment information, they have to make sure that they have all the business associate contracts in place, and they have to make sure they have the appropriate language in their plan documents as required under option 2. And that they have to also make sure that they have a business associate agreement in place with their broker. And if that information is created, received, or stored electronically, then they must also make sure they have security rules in place. And again, the same goes to as an employer who has a fully insured group plus an FSA or an HRA. They should have HIPAA training potentially and privacy practices in place, policies in place because of that FSA or the HRA. They may or may not need the security services. Typically they don't, because with an FSA and HRA, typically you're not creating or receiving any protected health information. And an employee with a self-funded plan, you have to fully comply with HIPAA if you're getting more than summary information. They should always read and understand business associate agreements, because that's going to tell you what your TPA is going to do in light of HIPAA and what you're going to do. So you always must make sure that you understand your business associate agreements and make sure you have them in place. And depending on whether or not you create, receive, or use electronic information in electronic format. We just did an audit on a company that they didn't use anything in electronic format, so they don't have to worry about HIPAA. And again, the broker should have a business associate agreement in place with all their clients and privacy policies in place if they receive more than summary information, because you always want to protect that information from the broker's aspect as well. So that's it for the presentation today. I think we went a little bit over, and I do apologize for that. But let's see if we have any questions. just bear with us for a moment while we put up the question area. With an FSA and HSA, when members file for reimbursement, how is that not HIPAA information? For information, if a medication is prescribed, isn't that protected info? And you are absolutely right. It is considered protected health information. But again, who is receiving that information? If the information is being received by the third-party administrator, then in the business associate agreement, it says that the third-party administrator will keep that information sacred and will not release it to anyone. So it will be up to the third-party administrator to make sure that they have the appropriate privacy and security measures in place. Then it depends on what goes back to the actual employer. If they're just receiving summary information that they already have, that, for an example, John Smith has, used $300 on his card, but the employer does not receive any information as to what doctor or what provider they went to, then that's considered summary information. And they may not have to have as many security things in place or privacy rules in place. However, whenever you look at the FSA and the HSA, look at the business associate agreement. If there's a breach, who's going to notify the individuals? If an individual requests an amendment, who's going to do that? Most likely you're going to see that it still goes back to the covered entity, and therefore they must have the things, the process in place. I hope that answers your question. We are a self-funded health plan with over 50 employees. The only protected information we receive is on claims issues by email. We have secure email systems between us and all TPAs. Is that sufficient to be compliant? Well, first off, you do have to make sure you've got policies and procedures in place because you are a self-funded health plan. You also have to make sure that you give out notice of privacy practice at least once every 3 years. And the other thing is that HIPAA says under the security rule is that you have to have a risk assessment and risk management plan, and then there's certain other things that are required. You probably are at a very low risk, but you would have to do certain things to become fully compliant with HIPAA in regards to having policies and procedures in place. When you do a risk assessment, depending on how everything goes, you probably have minimum risks, but it still has to be documented. And then we just had somebody that says, hey, we do everything that you mentioned, and we're really glad to hear that you've got a robust HIPAA plan in place, and that's what we like to hear from everyone. Don't forget that, HIPAA was meant to protect us all. The people were nervous with the internet and with the Genome Project, and we want to make sure all our information is protected. So don't forget, if ever you have any questions or want to discuss it further, please do not hesitate to contact us at MedCom, and we will be getting you a copy of this presentation next week. And I think that's all the questions we have for now. So thank you all for attending, and have a great rest of the week.